This is WAAY 31 Law Call.
Good evening and welcome to WAAY 31 Law Call. I'm Sharon Doviet. Tonight we're taking your calls and questions all about injuries. So that's everything from car accidents to medical malpractice, a pharmacy giving you the wrong medicine and it makes you sicker, a drunk driver hitting you, being hurt by a product that you bought. The 31 Law Call number, call in your questions, 256-536-0077. We're also going to talk a little bit more about medical mistakes. How do you prove, how do you even know if what happened to you was the doctor goofing up or whether you just got a bad outcome? It was just bad luck. Not every surgery improves your situation. How do you know if it was a medical mistake or just the way it turned out? And we always invite you to send in your email questions. You send them any day of the week on any legal topic to lawcall@waytv.com. And when we get to a show that's on point, we pull some out and we will have some of your email questions with us tonight. Getting us started tonight, we've got Michael Timberlake with us from Senyard Timberlake and League, joining us by Zoom. Good evening, Michael.
Good evening. Good to see you.
Glad to have you with us. We've also got Bart Senyard from Senyard Timberlake and League, who's standing by, Zooming with us tonight. Good evening, Bart.
Good evening. Glad to be here.
Glad to have everybody with us to answer questions all about injuries tonight. We're going to put Bart on hold for a second while Michael gets us started with opening statements tonight, talking about medical mistakes. Michael, how do you know if what happens to you with a surgery or a treatment and it goes badly, how do you know if the doctor goofed up or if you just had bad luck with it?
Yeah, I mean, that's one of the things that we get asked a lot is that if you get an outcome that you don't expect or there's some complications of a medical procedure, you know, at what point does that arise to the point where you should pursue legal action? You know, it always is you know, pertinent, or you want to, you know, ask an attorney if you think that there was something that went wrong during a medical procedure, and we answer those questions all the time. But just because there is a bad outcome or just because there were complications doesn't mean that there was something that wrong happened or that is legally wrong that happened. In order to prove a claim for malpractice in Alabama, you have to have an expert, you have to have another physician in the same position as that doctor come in and say that the other doctor did something unreasonable, and that's why you got a bad outcome or that's why you had some complications. You know, medicine is not always the exact same thing in every person. People can have different conditions, so people can have outcomes without medical negligence, although there can be situations where doctors have done things that were wrong. You know, medical errors are, you know, the third leading cause of death after heart disease and cancer. You know, 1 in 3 patients who are admitted to a hospital may experience a medical error, and there's, you know, about over 400,000 people that die as a result of medical issues that may have been preventable in a hospital. So these are things we want to look at, the things we want to examine. The keys to these situations is getting the medical records, reviewing the medical records, and then making a legal determination as to whether there's a case to pursue.
Good. Those numbers are really shocking. When you're saying 1 in 3 people admitted to the hospital experience some kind of error, that's alarming. Yeah,
it's definitely concerning. It may not always, you know, be an injury
right.
that results from it, but it's
right.
not. You know, there's a lot of concern going on in that arena.
We're going to bring back in Bart Senyard to join us answering questions tonight, because tonight we're talking all about injuries, and that's what you guys do every day of the week. It's everything from car accidents to medical malpractice. It's product liability kind of things. And I wanted to start with Bart asking, how important is it when something bad happens to you to get started with investigating it quickly or go talk to a lawyer quickly? It seems like time is really important.
Yeah, there's a few reasons why you do want to get started sooner rather than later. First off, there's a statute of limitations for any type of civil claim. For most injury type cases, it's 2 years in the state of Alabama. The second reason you want to get started earlier rather than later is what the attorney has to do is collect all the relevant evidence. So, for example, if you've been in a car wreck and there was a witness to that car wreck, we want to be able to track down that witness before the insurance companies are able to, because they can twist their words against you. So the first to the evidence, an old saying we have in our firm, the first to the evidence usually wins the case. So that's why it's important not to wait several months or years, but to call an attorney as soon as possible. And the other thing to keep in mind is that personal injury attorneys will meet with you for free. There's literally no downside to contacting an attorney, scheduling an appointment, and just seeing whether you want to move forward with it.
Good tips. We got this email question in from Mindy. Mindy had written to us asking, can the insurance company deny your claim if your 16-year-old driver violated the graduated driver's license rule and had 4 passengers in the car during the wreck? Okay, does something like that mean that the insurance company just doesn't have to pay? Who wants to start?
Well, I mean, basically there are different rules for people that are younger drivers,
right.
In terms of the number of people you can have in the car, the times of day that you're allowed to operate a motor vehicle without some kind of adult supervision. But simply because you're violating one of those rules does not mean that you're automatically responsible for a motor vehicle wreck. It doesn't mean that that you caused a motor vehicle wreck because you were violating one of those rules. Now, if you had 4 people in the car and you couldn't see, that'd be a different thing. But if you are insured, their insurance company will have to provide you coverage, even if you violate a rule of the road. If an insurance company could get out of a case every time that there was some statutory violation, then they would never pay any claims. They would love that, Bart.
Yeah, they would. They do try to get out on some occasions when a driver doesn't have a driver's license. Some insurance policies have exclusions that they won't cover a claim that is caused by somebody who doesn't have a driver's license. That may be in your insurance policy, so be wary of that. And there's other exclusions they can have, but if it's something like statute you're talking about, that's not going to affect the case, because like Michael said, in almost every car wreck, somebody has broken the law in some aspect, whether it's run a red light or driving under the influence or texting and driving. There's always, or almost always, some violation of some law. So that doesn't need to be of concern to them. The insurance company should cover that claim.
We've got callers waiting, guys. We've got Melissa on the line with a question from Huntsville. Hi, Melissa. Thanks for calling. What's your question tonight?
So my question is, in the state of Alabama, I was in a car accident in November of last year, and I was a guest passenger in the back seat with another family member driving. So is it considered the law that you can't sue someone if you are a guest passenger in the car?
Oh, very interesting. Okay, guys.
Yeah, and this is something that Bart and I talk about a lot, because it is a very bad law. Alabama is one of the very few states in the country that still support what is called a guest passenger exclusion. If you were, which basically says if you're riding as a guest, if it's just totally somebody's giving you a ride for free, just a friendship thing, you are going down the road and they're in a motor vehicle wreck, then and it's just simple carelessness, simple negligence that caused the wreck by the driver, then you cannot make a claim against the driver if you are a guest. If it's a gratuitous ride, then you cannot make a claim against the driver under that situation. Even if they were negligent, you cannot make a claim. Now, if they were a passenger or if there was willful conduct, it can be different, right, Bart?
Absolutely. And there's 2 exceptions to the guest passenger statute. And one is recklessness, or wantonness is the legal term. So if the person who's driving the car is drunk, or is speeding excessively, or just doing something that's really dangerous, then the guest passenger statute won't prevent you from being successful in your claim. So that's one thing you need to look at. The other exception that's commonly used, and I had a case that went all the way to the Supreme Court on this issue, is if you as the passenger are providing a material benefit to the driver, then the guest passenger statute doesn't apply. It's not a gratuitous ride. It's not just a friendly thing where y'all riding together. If you are paying for gas, then the guest passenger statute doesn't apply because you're not a passenger anymore. You're considered a guest. And the case we had was a lady was driving with her friend. She was going to help her to go grocery shopping, load the groceries up in her trunk, take them back home because her friend was elderly and she needed help grocery shopping. And we took it all the way to the Supreme Court, and the Alabama Supreme Court said that's a material benefit. The fact that you were going with your elderly friend to help her with grocery shopping, she could recover against her elderly friend's insurance when the elderly friend caused a wreck. So the guest passenger statute is something to worry about, but there are ways around it.
Very interesting. Okay, they're telling us to take a break. We're going to take a break and be right back answering more of your questions all about injuries tonight. We've got callers on the line. Greg, don't hang up. We'll get to you in just a minute. Stay with us. More all about injuries straight ahead.
This is WAAY 31 Law Call, with guidance from the Huntsville personal injury firm of Sinyard, Timberlake & League, devoted to helping victims of truck and car wrecks, medical malpractice, dangerous products, and wrongful death, with founding attorney Tommy Sinyard, helping injured Alabamians for more than 30 years. Attorney Michael Timberlake, managing partner and top-rated by fellow lawyers for legal ability and ethics. Attorney Will League, experienced in trying and winning cases across the state of Alabama. Hosted by award-winning broadcaster and practicing family law attorney Sharon Doviet, and guests from across the Tennessee Valley. Your rights, your calls, live. WAAY 31 Law Call.
And welcome back. Tonight we're talking all about injuries. We've got with us Michael Timberlake and Bart Sinyard, both from Sinyard, Timberlake & League. They are personal injury attorneys and they handle these kind of cases all day, every day. And personal injury cases can be everything from car crashes to medical malpractice cases to product liability cases. And guys, I wanted to ask some things about product cases. Seems like every Christmas there's something that comes out, the holiday present that turns into a big personal injury case. In years past we had the hoverboards. Are y'all seeing anything that's coming out of 2020 or maybe 2019 that have become big problems with product liability cases?
Gosh, in terms of Christmas, I don't know if there's anything in particular that was a real game changer. Now, what we are seeing is products like pesticide use. Roundup has been a huge product that has been in the news, and there have been multi-billion-dollar settlements by Bayer for users of Roundup associated with cancer, and that's something that certainly is people wanted to look at. There have been talcum powder cases involving Johnson & Johnson and ovarian cancer those are kind of the two of the top ones we see lately that have been in the news. Obviously there was pharmaceutical litigation with Purdue Pharmacy over opioid or OxyContin, and that was it's been going on for the past couple of years as well.
Interesting. Okay, y'all, we've got callers waiting. We've got Greg on the line with a question from Collinsville. Hi, Greg. Thanks for waiting. What's your question tonight?
Yes, I was diagnosed with bleeding on the brain, and I didn't have it. And I'm just maybe trying to get some, some logical that maybe I can go about doing that.
So you didn't have it, so that's good news, right? Did they give you treatment for it in thinking that you had bleeding on the brain? What kind of treatment did they give you?
Well, they took me to, I believe, I'm not for sure, down here in Birmingham, and they told me, well, you didn't have it, bleeding on the brain.
Okay.
So,
Right. Well, in every case, there are two things that you have to have. One is there has to be some, in a medical case, a violation of the standard of care, in an automobile accident or whatever, negligence. There has to be some culpable conduct. There has to be some wrongdoing, an act or omission that shouldn't have occurred. And that may be the case in your situation where somebody either misdiagnosed you or didn't see something that was there or saw something that actually wasn't there. So you could potentially, have a situation where you have, liability. But in every case, you've got to have both liability and damages. You have to have an injury associated with that. In this case, Bart, what do you think about the damages?
Well, you have to have some direct harm that is caused by their misdiagnosis. This is one of the frequent situations we see, is that a lot of times at the ER they will miss something on an X-ray or a CT scan, and then you find out a week or a month later, I didn't really have what they said I had, or I have something and they didn't catch it. Well, unless the fact that they messed up caused you to suffer some new or additional harm, some kind of medical treatment that was invasive that you didn't really need, or you developed some further complication down the road because they misdiagnosed you, you probably don't have a valid malpractice case unless you can connect their violation of the standard of care to some serious harm. And you may say, well, for days or weeks, I thought I was bleeding on the brain. At least that's some psychological harm or some emotional harm. In Alabama, there has to be some physical harm to your body before you can recover in a medical malpractice case or any personal injury case. So in your specific situation, and that's why Sharon kind of asked you that follow-up question, what was done as a result of this misdiagnosis? If you didn't have any further complications from their misdiagnosis, then it's probably not a case worth pursuing. But if you think there was some issue that you had as a result of the misdiagnosis, it's worth getting your medical records and contacting an attorney.
Very interesting. Greg, we're glad that you're okay. It's a good outcome overall.
Absolutely.
We've got Mr. Moore on the line with a question from Russellville. Hi, Mr. Moore. Thanks for calling. What's your question tonight?
My question is, I was in a car accident, me and my wife.
Okay.
A lady hit us, and she hit a truck. The truck hit us, and it broke 6 of my vertebrae and broke my arm and her arm, and she had a concussion.
Wow.
Well, my insurance, her insurance paid what they was going to pay. So I had uninsured motorist coverage, and they don't really want to pay nothing. And she's still seeing doctors, and I'm still having back problems and paying bills and stuff, both of us. So I was trying to find out, they did try to give her $5,000, me 10, but that's not going to finish taking care of our bills, and it's also not going to, help for my pain and suffering, and hers neither.
Yeah, and how long ago was your accident, Mr. Moore?
It was July
2020?
2019.
2019. Okay, guys, what direction do you point him?
Yeah, in Alabama, you have a mandatory minimum liability coverage of $25,000. People can have more than that. It can be 25, 50, 100, 250, 500, $1 million for liability coverage. Once that coverage is exhausted, once it's gone, then you can make a claim against your own carrier for underinsured motorist coverage, and it would, you can combine or stack as many as 3 policies. They're typically written in $25,000 increments, or $25,000 per vehicle. So you can stack those, and your insurance company has to pay you up to the reasonable value of your claim for your injuries. Now, the benefit of a situation with uninsured or underinsured motorist coverage is, Bart, sometimes we get to sue the insurance company directly instead of suing individuals.
Yeah, absolutely. He probably needs to contact an attorney if he's not having any luck with his own uninsured motorist carrier. What we really like as personal injury attorneys is when we have the opportunity to bring a claim directly against our client's own insurance company. a lot of people are kind of hesitant to do that. But the value of a case against your own insurance company versus the value of a case against another individual who caused the wreck, it's different, because when you sue somebody who caused the wreck, the jury has no clue and does not get to find out that they had car insurance. But when you're making an underinsured motorist claim against your own insurance company, the jury gets to know this case is really against an insurance company and tends to award higher verdicts. So, I would really encourage you to reach out to an attorney. You think your insurance company should be on your side. You've been paying premiums for who knows how long. But when it comes down to it, when it's time to make this type claim, they will lowball you, because the less they pay you, the more profit they make. Would strongly recommend contacting an attorney who's handled these.
And if his accident was in June 2019, he's getting close on time, right?
Well, typically you have 2 years from the date of the wreck in order to pursue a claim. If you're pursuing a claim for underinsured or uninsured motorist coverage, that can be extended to 6 years. Okay. But you don't want to wait. It sounds like in this situation that the insurance company's not taking him seriously if he's unrepresented, and we see that can happen a lot. These injuries are serious. They should have to pay a significant sum of money in addition to what they've collected from the other driver to resolve the claims.
Good information. Mr. Moore, good luck with it. We're going to take a break. Be right back answering more of your questions all about injuries. Stay with us. Next week, February the 14th, we're talking love and the law. So we'll talk about divorce and family law issues. February 21st, wrongful death claims. And February 28th, we'll talk about Social Security disability insurance claims, SSDI claims. If you didn't get your questions answered tonight, here's how to get in touch with Michael Timberlake and Bart Senyard. They are with Senyard, Timberlake & League. They are personal injury attorneys, and the number is 256-536-0770 or 800-804-2502. The website is law-injury.com. And if you like them on Facebook, you can learn more about the law that way. I practice family law, divorce, child custody, 539-7337. Guys, in our last seconds here, we've gotten an email question from Lexi, COVID related. I haven't been able to see my aunt in the nursing home for almost a year. How am I supposed to know if she's being treated well if I can't see her? Any quick advice for her on that? Hopefully it's getting better as treatments are coming along.
We're seeing the same, same type of problems, and as far as access to patients in nursing home to try to figure out what to do. We're encouraging to, try to set up some technological solution like we're doing here with Zoom. As more patients are getting vaccinated, there's better access. But it really is a problem that we're having to deal with, and obviously. The nursing homes and the staff of the nursing homes and the other patients at the nursing home want to control access, but we're really, seeing a lot of problems that have occurred that have not been detected or disclosed with people in nursing homes, and it's something to be concerned about. If you have a question, you can call the state. There's a complaint hotline through the Alabama Department of Public Health, or you can call a long-term care ombudsman through our TARCOG and get somebody to give you some answers about your loved one.
Excellent tips. Thanks, guys. Thanks, Michael Timberlake and Bart Senyard. Thanks. Have a good evening. Thanks for all your questions tonight, everybody.